your Lordship will just allow me, this Pradhan Mantri Khanij Kshetra Kalyan Yojana, which is at page 47, is very useful. It will repay study. I don't have the time to show it. Please make a note and please see it, fellows, at your Lordships. The center covers the entire gamut and tells you how to use the money till the last user. This Pradhan Mantri Yojana, fellows, is page 57, is very comprehensive. And it is issued under section 20 capital A of the Act. So here one sentence. This extent will not have any problem here because coverage is complete. The coverage cannot mean multiple piecemeal legislations. I gave the example of the coat and the gown and the band yesterday. You cannot have multiple legislations that because I covered the coat and the gown, tomorrow somebody can do on shoes. That its intention is to leave that to the center and not tax it. There is an implied prohibition there clearly. Then para 19. Now just see, Odisha Cement says, all these are ignored, I mean, not ignored, they're just brushed aside, cited and brushed aside. The object of 9 cannot be ignored. 25 implicitly authorizes the levy of rent, royalty, taxes and fees, directly the issue. But if your Lordship total the number of judges who are spread over India Cement, Odisha, synthetics is coming. So all judges have the same view. I mean, your Lordship is of course plenary. But why should your Lordship give so much weight to Kshetra? This is the only dissonant judgment. Now see the next one. Synthetics is very interesting. My Lord is hearing synthetics on the other point of entry 3 list, entry 33 list 3. This is a different point, very interesting. 7 judges have held so. 9 or 7? 7. Now see Mahanadi. So Odisha I have done in 19. Now see 20. 20 is Mahanadi. A perusal of the MMDR, all the sections are given, will clearly point out that taxation on mineral and mineral rights, any tax, royalty, fee or rent are provided in the said act. The state legislature is denuded or deprived of the power to enact. Then 21. These are calculations I have given. Your Lordship may just keep it in mind. I will save time by not reading it. I am only adding to Mr. Tushar Mehta as well as impassioned plea about various monies where they go. The last part of para 21 is very interesting. He's given you the details. I don't have to go. That's the government's job. But just see, all these total to about 16 to 21% of the average sale price. Last line, above para C. Above para C, my Lord has got. All my Lords have got the line above C. Total of all these levies, which is 9, 9A, 9B, 9C. Of this 21 or 16%, 0.3% is retained by the center. The previous line above that. That is 2% of royalty NMET. That is 0.3%. All the rest goes back. Now let's see next para C at page 315. Most significantly, all these levies except NMET, that is 0.3, admittedly go to the state government coffers. Then state-wise breakup is given. Mr. Mehta has dealt with it. I am not going to deal with it. 2 more para that I am done with this part. 23 at page 316. Now it is true that the general standard Sundaramaya Iyer concept of grouping is there. Before I read it, my answer is simple. That is not a mechanical sorting machine. Where this article leads you, Lordship, to think differently, that is 50 special unique architecture, then that grouping is not cast in stone. That's my submission in 2 paras. Sundaramaya Iyer is valid, but it says itself, it's not exhaustive. Sundaramaya Iyer, that judgment which says grouping, says itself that don't treat it as exhaustive. There may be entries like 50 which don't allow grouping because they're uniquely worded. My Lord, if I may say, called it 8 mantras, Honorable Chief Justice 2 days ago. I've dealt with that. Let's kindly come to 823. You have to, therefore, not be a slotting machine. You have to go entry wise. Mostly Sundaramaya may apply, sometimes will not apply. Your Lordship's analysis or interpretation can't be straight-jacketed by a Sundaramaya focus that no, I have to group. This is a unique architecture. This one is not a grouping architecture. It is 54, 97, 50. It's a totally different triangle. Now come to verse 23. For these reasons, 50 and 54 read with 97 imply a sui generis and complete code on regulation of mines and mineral development and taxation of minerals and mineral rights, as the state's power of taxation in entry 50 as well as general powers are both subject. Both is italicized. Then let's come to 24. 26. I'll skip 24 to save time. Come to 26 straight away. This is, the word mantra is replaced by the word sutra here. The Roy's case from Assam acknowledged that the scheme of the 7th schedule cannot be governed by a straitjacket. Our endeavor is, because he goes against the Guire principle. The Guire principle is grouping. So he says, no, it can't be a straitjacket every time. Our endeavor is only to demonstrate a great deal of examination, etc. No rule which has a universal application with regard to the interpretation of all entries can be postulated. That's my point. That's my respectful submission. The statement of Justice Guire, Chief Justice Guire, that a broad and liberal spirit should inspire and the legislative entries should not be read in narrow, cannot be understood as a sutra valid for all times and in all circumstances. That's the only point I want to say, Malas. And Malas, para 26, next page 318, I have mentioned the 8 mantras, 8 formulations which the Honorable Chief Justice has done. I am Malas now coming to 27, which is a little noticed, but an extremely important paragraph, 827. 7 judges in synthetics, not on the point your Lordship is considering next week, say the power to levy taxes is to be read from the entry relating to taxes and not from the general entry. Exception in entry 50 of list 2 where tax on mineral rights is subject to any limitation imposed by Parliament relating to mineral development. And this power of Parliament is in general entry. There can be no more direct than this, Malas. Now, you may say, Malas, that 9 judges is wrong or right, but certainly, Malas, Kshetra, with greatest respect, had no business to, Malas, brush it aside. Then, Malas.
The power to impose a limitation has to be read under entry 54. That doesn't mean the power to impose a tax is to be read under 54, read with entry 97.
2 answers, Malas. It means a tax because of the language of 50. That's the opening word of 50. 50 cannot contemplate a limitation which cannot be a tax limitation. Answer number 1. Answer number 2. 7 judges have said exactly what I've said just now.
No, it's a limitation on the power to impose tax.
No, tax it says. Synthetic says tax.
Yes, the limitation on the power to impose tax means the power resides with the state. The limitation emanates from entry 54.
Yes.
Correct.
Therefore, the power resides in the center also, Malas. The center cannot impose without all the power, Malas. The power has to be in the center, Malas. And a superior power is the center.
I'm trying to say is the power to impose a limitation doesn't take within itself the power to impose a tax.
Malas, with respect, let me examine. That's a new nuance, my lord. Give me 2 minutes. Malas, how do you limit a tax without reducing or imposing? Suppose the state imposes 1%. I want to limit it, I say abolish it. Your Lordship has to assume that I have the power. If the center has no power, the matter ends. Your Lordship will not be able to control it. Limitation has to include from 0 to 100.
Can say we are abolishing the power of the states to levy the tax, but we are going to levy the tax. That's not the scheme of the Constitution.
No, by 97 they will have the power, Malas. If your Lordship resides the power, it has to have the power. With respect, Malas. With respect, that will be an artificial limitation. No, Malas, let me just explain.
Very clearly,
Let me explain, Malas.
It is very clearly divided, Dr. Singhvi.
Yes.
The state is given the power to levy the tax.
Subject to limitations.
Subject to limitation, we understand that. And we go into the limitation of 54. But you are trying to bring in 97 as also a power to levy tax. How can the residuary entry be utilized for this purpose?
Can I? First question to be decided is, does the center have the power or not? Matter ends if your Lordship finds they have no power on taxation. That's the primary question. All this debate is if they have some power of taxation. My answer is they have to have a power of taxation because the limitation envisaged and recognized by 50 itself is a limitation on taxation. 50 itself recognizes that you, my superior, has the power. We stop here, Malas? Unless we accept the fact that 50 dealing with taxes, using the word limitation, recognizes a superior person, then we can't go further. Now we come to a different nuance, which my Lord Justice Nagarata has asked. Yes, taxation is also within 54 because the look back by 50.
There is an entry 50 list 2 the power to impose a limitation on
Quay taxation.
54.
Right, let's accept that. The power to impose a limitation, quay taxes. We are only considering that, right, Police? Now, my two submissions there are, if your lordship concede, this is only a debate, lordship doesn't have to concede or accept, your lordship decide. But if your lordship accepts a power that taxes can be limited by the central government under 54, then two facets. One, the word limited by central government has to include the plenary power from 0 to 100 is the first submission. It's not that your lordship gives him some power and not gives him some power. He either has the power or doesn't have the power. On taxes. And I say he has to have the power on taxes because 50 looks back. Now the second facet. Once he has the power, I am only using...
to limitation.
Yes, right.
But limitations quite taxes because the entry is on taxes.
It does not transfer, the limitations do not transfer the entire field of taxes on mineral rights to Parliament under entry under list 1.
No, if Parliament chooses not to do so, yes. But it's kindly go to 50.
Because
Let's go to 50.
you know the danger, look at the grave danger to the Indian federal structure by accepting your argument.
No, Parliament can decide not to
Suppose
play.
Parliament prevents, suppose the limitation assumes the character of a prohibition. Because there are judgments that say a limitation can amount to a prohibition. Then, on the one hand, Parliament can prohibit the states, but it can say, I have prohibited the states, so now the entire field is left to me.
There's a little
Under
difference.
list 1. Point number 2. Parliament imposes limitations. It can say, I have limited the states, but I am unlimited. I can impose a tax minus those limitations.
Can I answer?
That was never the.
Can I answer
That
this?
was never the intent.
Can I answer that?
And appropriate what the Chief Justice was saying, you see, merely because bulk of the revenue collected goes back to the state would not meet the argument that
That's
the
a
Chief Justice
constitutional
was
argument. This is a factual argument. There are two different things. I'm not, one is your lordship first has to locate the power. This is not a question of fact whether I give you back or not. That's not, I'm not arguing that.
the limitation in on mineral development.
No, therefore, now let's just look at 50 for a minute. Just look at 50. I know this is too late in the day to look at 50, but let me give your lordship 1 minute. Taxes.
Asmita, आमची power आहे.